This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we speak about the problems with asbestos lawsuits and the reason why a plaintiff must be an insured to receive a defense from an insurer, and why even the Eight Corners rule could not stretch a policy to provide coverage. Brilliant National Services, Inc. appealed a summary judgment rendered in favor of the defendant Lexington Insurance Company, which dismissed all of Brilliant's claims against Lexington with prejudice and declared that Lexington had no duty to defend or indemnify Coastal Chemical Company, LLC, the predecessor of Brilliant. In Brilliant National Services versus the Travelers et al., a September 7, 2022 decision of the Louisiana Court of Appeal, Brilliant had sued Lexington, among other defendants, seeking contribution for the costs of defending CCC LLC in a number of asbestos exposure personal injury lawsuits filed in various state courts in Louisiana beginning in 2011. Brilliant alleged that Lexington issued a general liability insurance policy to its insureds for the period of August 20, 1986 through August 20, 1987. Brilliant alleged that certain plaintiffs in the asbestos lawsuits claimed that CCC LLC was the successor to an insured entity under the Lexington policy that was alleged to have manufactured, distributed, marketed, or sold asbestos-containing products. Brilliant claimed that if CCC LLC was found to be the successor to an insured entity under that Lexington policy, then the insured entity's rights under the policy transferred to CCC LLC by operation of law. Brilliant further alleged that regardless of whether CCC LLC was the successor of an entity insured under the policy, Lexington owed CCC LLC a duty to defend based on the allegations raised in the asbestos lawsuits and the terms and conditions of the Lexington policy. Brilliant sought declaratory judgment that Lexington owed a duty to defend CCC LLC in the asbestos lawsuits. Brilliant also sought judgment in its favor and against Lexington for 1/7 of all attorneys' fees and costs paid by Brilliant in defense of CCC LLC in the asbestos lawsuits, together with legal interest costs and all other relief to which Brilliant may be entitled. Lexington answered, raising numerous affirmative defenses, and moved for summary judgment, seeking a judgment in its favor, declaring that CCC LLC has no rights under the Lexington policy, dismissing the claims asserted by Brilliant and awarding judgment in favor of Lexington on its demand against Brilliant and CCC LLC. They, of course, opposed the motion. The trial court granted Lexington's motion for summary judgment, dismissed all of Brilliant's claims against Lexington with prejudice, and declared that Lexington had no duty to defend or indemnify CCC LLC. Summary judgment declaring a lack of coverage under an insurance policy in Louisiana may not be rendered unless there is no reasonable interpretation under which coverage could be afforded when applied to an undisputed material fact shown by the evidence supporting the motion. Where the facts are undisputed and the matter presents a purely legal question, summary judgment is appropriate. The court, discussing the case, concluded that an insurer's duty to defend its insured arises solely under contract. Generally, the insurer's obligation to defend suits against its insured is broader than its liability for damage claims. An insurer's duty to defend its insured is determined by the allegations of the plaintiff's petition, with the insurer obligated to further furnish a defense unless from the petition it is clear the policy unambiguously excludes coverage. An insurer's duty to defend suits on behalf of an insured presents a separate and distinct inquiry from that of the insurer's duty to indemnify a covered claim after judgment against the insured in the underlying liability case. In moving for summary judgment, Lexington argued that it had no duty to defend or indemnify CCC LLC nor its subrogee Brilliant, because CCC LLC is not and has never been one of Lexington's insureds. The Lexington policy defined named insured as the person or organization named in Item 1 of the declarations of this policy. The policy lists the named insured as Coastal Inc. and Coastal Chemical Company. Coastal Inc. and Coastal Chemical Company were the persons insured under the Lexington policy. The parties do not dispute that the Lexington policy expired prior to the formation of CCC LLC's predecessor, the second Coastal Chemical Company, Inc., which was incorporated on December 8, 1987. Because neither CCC LLC nor its predecessor was a party to the Lexington policy, CCC LLC cannot be a named insured under the Lexington policy. Furthermore, neither CCC LLC nor its predecessor falls into the definition of persons insured under the Lexington policy. Lexington argued that successor liability doesn't apply because CCC LLC could only be entitled to defense and indemnity under the Lexington policy if it or its predecessor acquired the named insured's Coastal Inc. or Coastal Chemical Company's rights and interest in the Lexington policy. Lexington explained that its policy had never been transferred to CCC LLC or its predecessor. In 1987, Coastal Chemical Company, Inc. acquired the chemical distribution business of Lexington's insured, Coastal Inc. Brilliant and CCC LLC identified the 1987 asset transfer agreement as the only documents through which the Lexington policy could have been conveyed, sold, or otherwise transferred from Lexington's insured to Coastal Chemical Company, Inc. The 1987 asset transfer agreement documents show a list of transferred assets, and the Lexington policy was not listed nor referenced in the asset transfer agreement. Lexington averred that because its policy was not transferred from its insured to Coastal Chemical Company, Inc. in the 1987 asset transfer agreement, CCC LLC never acquired the policy nor any rights thereunder from its predecessor. Accordingly, Lexington argued successfully that it had no obligation to defend or indemnify CCC LLC or its subrogee, Brilliant. The key consideration was whether the successor is in fact a continuation of the predecessor. The threshold requirement to trigger a determination of whether successor liability is applicable under the continuation exception is that one corporation must have purchased all or substantially all the assets of another. In the instant case, CCC LLC admitted that Coastal Chemical Company, Inc. did not purchase all the assets of Coastal Inc., only all the assets necessary to operate a chemical distribution business. There is no dispute that Coastal Inc. retained assets and remained in business after the 1987 asset transfer. Since the 1987 Asset Transfer Agreement excluded the Lexington policy from the list of assets acquired by CCC LLC's predecessor from Lexington's Insured, to conclude that CCC LLC acquired the Lexington policy, the appellate court would have had to ignore the parties' contract, and it was unwilling to do so. Then they tried the 8 corners rule. That rule, applied in Louisiana, is that if the 8 corners of the complaint compared to the 8 corners of the policy reveal a potential for coverage, the insurer must defend. Lexington contended that the appellants could not point to any factual allegations made by the plaintiffs in the underlying asbestos lawsuits, which, if assumed true, transform CCC LLC into a person insured under the Lexington policy. Cases applying the 8 corners rule hold the insurer owes a duty to defend if, and only if, assuming the factual allegations are true, there would both be coverage under the policy and liability to the plaintiff. The allegations of the petition are liberally interpreted in determining whether they set forth grounds that bring the claims within the scope of the insurer's duty to defend. An insurer's duty to defend arises whenever the pleadings against the insured disclose even a possibility of liability under the policy. Although the allegations of the petition may ultimately turn out to be incorrect or untrue, the insurer would still be obligated to provide a defense. Even though the asbestos plaintiffs allege that CCC LLC negligently and defectively designed, manufactured, marketed, distributed, supplied, sold, and used the asbestos products, those allegations do not trigger coverage under the 4 corners of the Lexington policy. The pertinent Lexington policy provision clearly defines persons insured and includes only specific individuals. None of the asbestos plaintiffs' allegations could, even if proven, transform CCC LLC into an individual defined as a person's insured under the Lexington policy, that is, an executive officer, director, or stockholder of the named insured, Coastal Inc. or Coastal Chemical Company, and therefore the Court of Appeal affirmed the trial court's summary judgment. In my opinion, asbestos claims have destroyed or bankrupted multiple insurers. As a result, those insurers still viable are, like Lexington in this case, the targets of defendants seeking defense and indemnity for claims of injury by exposure to asbestos. In this case, the Louisiana Court of Appeal could find no coverage because there was no way that they could stretch the language of the policy to make the plaintiffs fit within the definition of insured. No stranger to a liability policy can be allowed defense or indemnity. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog, and I'd appreciate it if those of you who do subscribe so that you can learn about future videos and future blog postings. If you found this video and the blog posting to be useful to you, please tell your colleagues so that they too can subscribe to the blog as well as to my Substack and my locals community. Thank you for your attention.